What is a good? A good is a tangible thing that is movable, meaning it must be something you can touch, something that is tangible. A computer, a desk, a TV, a barrel of oil, things that have the nature of being touched. The second aspect of a good is it must be movable. I must be able to take it from place to place. A good is movable. In the world of property, we talk about real property and personal property. Real property would be anything that is the land or is attached to the land in such a way that moving it is difficult. So a house remains not a good, even if theoretically you could move the house. So a good is a tangible thing that is movable. And that's the only transaction that Article 2 will govern. So on your test, there may be situations in which I ask you, which is the applicable contracting system here? And what you're going to look at first is it a contract for the sale of goods? A tangible thing that is movable. Now, questions often arise, does Article 2 apply to the contract? Why? Because the remedies of Article 2 may be different from the common law. Therefore, we need to look to see what contracting system applies to which particular event. Now, Article 2 does not govern contracts for services, real property, or intangible personal property. So things like real estate or employment contracts, those are contracts for services or for real property. The UC doesn't apply to insurance contracts. Again, insurance contracts are a service, right? You're providing insurance. Even though it may refer to an actual tangible, movable thing, the insurance contract itself is not subject to Article 2. Finally, the UCC doesn't apply to the sale of intellectual property, trademarks, copyrights, patents. The UCC does not cover any of those items. What happens, however, when you have goods or services that are combined in a single contract? There are a large number of disputes involving goods that also involve services or real property or intangible or immovable personal property. Now, the thing you need to know, and it's very important for your test, so put a star by this one, only one contracting system can apply to a transaction. So if you see a question on your test and about which contracting system applies, and I say this is a mixture of the common law and the UCC, that's the wrong answer. Only one contracting system can apply to a transaction. So how is it in the case of a mixed contract, a mixed goods and services contract, how is it that courts determine which contracting system to apply? What's an example of a mixed contract? Well, something like you're going to get a swimming pool installed. You contract with a swimming pool company, and they are going to come in. They're going to dig a big hole in the ground. That's a service, right? Clearly a service. They're going to pour whatever concrete is necessary. They're going to fill it up. But they're also going to include goods in that package. So there will be a slide or ladders or diving boards. Those are goods. So how do we know which contracting system to apply? Well, there's two tests. Courts use two different tests in order to determine whether the common law applies or the UCC. And again, it's important because the common law and the UCC may differ in terms of what is a valid contract, what is performance, what are remedies are available. So in the majority of states, and for the purposes of our test, we're going to focus on the predominant purpose test because this is 2/3 of the states. In those states, courts determine what is the main purpose of the contract. Is it the redemption of a service with goods that are just incidentally involved, or is it the sales transaction with labor incidentally involved? So in this question of the predominant purpose test, what courts are looking at is what is the main purpose of the underlying transaction. If I'm going to hire you to install solar panels on my roof, well, what's the major purpose of that transaction? Is it the installation or is it the purchase of the solar panels? And it's an area where there's oftentimes no easy answer. In this case we have here, Mallow Associates versus North Avenue Development Corp., that involved a situation of a sprinkler system. Company had hired someone to install a sprinkler system. They were going to pay for the sprinkler parts, and the other party were going to install those parts. So it was a mixed goods and services contract. The sprinkler system fails. The inventory is soaked, destroyed. Which contracting system should apply? Well, what the court said is that we should look to see what was the predominant purpose of this contract. Was it installation of sprinklers, or was it the purchase of the pipes and the sprinkler heads? And in this case, the court said the main purpose of installing the sprinkler system was installation. They were relying on the knowledge of the party that was installing the sprinkler system. The sprinkler heads and pipes were an incidental matter. They weren't the main purpose of the underlying transaction. So for purposes of your test, just know that the predominant purpose test is what is used in most of the United States. Now the other states use what's called the gravamen test. And this is about 1/3 of the states, maybe 1/4. And in this situation, we look to see what part of the underlying transaction gave rise to the dispute. If it is goods, then Article 2 applies to the dispute, even if the predominant purpose of the transaction was to sell or to buy services, non-goods. If the source of the dispute arises out of non-goods, then UCC Article 2 does not apply to the dispute, even if the predominant purpose of the transaction was to sell or buy goods. Now in this case, Anthony Pools versus Sheehan, we come to that situation of a swimming pool in which a homeowner hired a company, Anthony Pools, to install a swimming pool, but they also purchased things like a diving board and ladders and a slide. In this case, the diving board failed. The diving board was a failure, and that was what caused the accident. Now, if you were to look at this from the predominant purpose aspect, you would look to see, well, what was the purpose of that transaction? Installation of the swimming pool. Goods were incidental. But if we apply the gravamen test, then we look to see what was the dispute about. In this case, there was an injury caused not by the installation of the diving board, but by a faulty diving board. The diving board, the good itself, was faulty. And so in this case, we look to see, we say that In this case, Article 2 applies to the dispute, even if the predominant purpose of the transaction was to install a swimming pool. So the predominant purpose test, the gravamen test, these are things to look at when deciding what contracting system will apply. By the way, one shortcut you could use in this situation of the predominant purpose test is to look to see if the values of goods and services are separated in the contract. Look to see what was the majority part of that contract. So for instance, if I was buying solar panels and arranging for the installation of solar panels on my roof, if in fact the solar panels, say it's a $50,000 contract, the solar panels, the cost of the solar panels is $40,000, installation is $10,000. In that case, it would look like the predominant purpose of the transaction was the purchase of solar panels. What this means is that we can use this money situation to provide some sort of guideline. If the situation were reversed, and in fact the solar panels cost $10,000 and the installation cost $40,000, then that looks like the main purpose of the contract was the installation.